On this episode of Law Weekly, we speak with the issue of the constitutionality of the law establishing the Economic and Financial Crimes Commission, EFCC, and the suit by 16 state governments challenging same. Also showing on the program, magistrates in Rivers State have asked the state government to consider increasing their retirement age from 60 to 65. Why? We'll find out in a bit. For the recap of the top trending stories in the news. Hello and welcome to the program. I am Shola Sheyedi. Last week on the show, we had the views of Senior Advocate of Nigeria, Yinka Olumide Fushika, on the very contentious issue of the legality of the EFCC. On this episode of the program, we serve you another view. My guest is Senior Advocate of Nigeria, Professor Fidelis Odita, QC. But before we get to that issue, the economic policies of the government and its consequent hardship on the majority of the people occupied our minds. Professor Odita says the policies are necessary, but the implementation has been very poor.
I think in a vacuum, the economic policies seem necessary in a vacuum. So obviously we need to address subsidy, not necessarily for its own sake, but because of the corruption that has become attendant to subsidy. That's the first thing. Secondly, we need to address, I think, electricity tariff so as to encourage investors to come into the sector, because obviously if the tariffs are uneconomic, no sensible investor is likely to come in, and the government, having divested, would find it difficult to provide it. And then in relation to the currency, obviously we needed to do something about the currency for a number of reasons, partly to avoid the fraudulent arbitrage between official rate and market rate and black market rate and so on. So yes, in a vacuum, those reforms were absolutely necessary.
Why do you say in a vacuum?
The reason I say in a vacuum is because the reforms needed to be tailored to the difficulties or to the circumstances which prevail in Nigeria. I, as a person, would not have introduced those three reforms at the same time. In particular, I would not remove the subsidy on petrol and devalue the naira at the same time, even if I call it convergence between the official and the parallel market. So I think it's a combination of an import-dependent economy and devaluation of the naira, which has caused the massive inflation and hardship that we see. But on their own, which is why I said in a vacuum, on their own, those reforms are necessary. You've got to remove subsidy because more money is stolen through subsidy than actually benefits the users of PMS. There are certain things that are good on paper, but the implementation has to be correct. Otherwise, it will have negative consequences. So the three key reforms that have been effected here are absolutely necessary, but could they have been implemented differently? Absolutely.
Let's switch gears, Prof, and talk about the law. What does the law say, Prof, about the legality of the EFCC? Can the governors challenge and resist the moves by the anti-graft agency to prosecute them and investigate their finances?
I think the governors are doing that not with any sense of patriotism or in order to enforce principles of federalism, but just to cover their own backsides. It's well known that the governors are completely unaccountable. They have mismanaged and stolen most of the monies allocated to their state. The only concern they have is being prosecuted by the federal agencies, the EFCC especially, because the ICPC has shown very little appetite to chase the governors. And I think it is right that they should chase them because you have got to be accountable to the people. But the condition that we find most states where the governors are wholly unaccountable to anyone. If you now took them out of EFCC and subjected them to their own state public complaints commissions, you will know that it's a joke. It's just like what happens in relation to state election bodies, where in every state, or in most states, let me not say every state, in most states, the ruling party wins all the local governments. So I think purely as a matter of practical necessity, they have to remain accountable somewhere. So to an extent, there are indications, I won't put it as high as that the EFCC could enforce financial and economic criminal legislation against state government. And as a practical matter and as a matter of morality, it is good that they should do so. I don't actually see that it undermines federalism in any way. I mean, federalism doesn't mean lawlessness and lack of accountability, the way that some of the state governors want to behave. It's just unfortunate that those institutions themselves are very weak and provide very little accountability for the governors, even the EFCC itself. So I'm not sure why they're worried about it.
One motivation for the case filed by the states is the accusation that the EFCC is a political tool in the hands of the federal government to harass states and witch hunt certain persons. You've defended cases against the EFCC that I am aware of and I've covered, but what has been your experience with the EFCC? Has that body, do you agree do you think that body has lived up to its mandates and continues to deliver on, the function for which it was set up?
I think the EFCC was set up during the tenure of President Obasanjo. The objectives were entirely laudable, and in part, it was to implement the UN Convention on Corruption. And I think for at least the first few years, it appeared to be narrowly focused. But even during Obasanjo's regime, it was also clear that it was used for witch hunting. So the witch hunting aspect almost came with it. It was used with this formation. It was used as a political tool to harass people. I remember how it was used to harass Amechi, who had been nominated initially to be the candidate of the PDP in Rivers State, and because of the EFCC, he wasn't allowed to run. And the same thing for Peter Odili, who wanted to be president and then subsequently vice president, and they used the EFCC to stop them. So you can see that the EFCC is often used as an instrument for harassment. And I dare say Mr. Yaya Bello will be saying the same thing. But of course, in the case of Yaya Bello, there is some evidence that he used state monies to pay 10 years school fees for his children. So if nothing else, he must be accountable for that. And it would have been wrong to allow him just to misuse state funds in that way. And when he's asked to account, he shouts that he's been harassed, witch hunted because he didn't support or because he contested against Tinubu in the APC primaries. But it's not just the political witch hunting. I think that the EFCC has lost its ways in many respects. So there are a number of cases in the law reports where the courts have been telling the EFCC they cannot be used for debt collection. But notwithstanding that there are at least 20 such cases, the EFCC continues to be used to harass private individuals where there is no element of corruption, no economic crime, no financial crime. A simple debtor-creditor matter. The EFCC gets hired for a cut to take a percentage of a recovery. So it becomes a debt recovery agency. And there are also allegations that even the EFCC officials themselves are more corrupt than the people they arrest. And we saw during the last transition where one of the governors, I think of Zamfara State or somewhere, said that the former EFCC boss asked him for $2 million and he refused and he was trying to arrest him. So there must be many such instances, and those are instances of abuse of power, which unfortunately are very prevalent.
In terms of reform of the EFCC, what would be your suggestion?
I think that the EFCC, they need to sack all the current employees of EFCC.
Really?
They need to start afresh, because I would have said, there are many ways. In some respects, there's overlap between the ICPC and the EFCC. And really, there is no need for them to be struggling for territory. But I fear that a simple amalgamation of ICPC and EFCC isn't going to address the problem, because the rot in EFCC is so deep and the corruption so entrenched that because there's a culture of corruption among them, if you took them to a new body, they'll simply continue from where they stopped. So that's not going to be a solution. And I fear that they'll need to release most of them and get new people, not just new leadership. Yes, of course, we always say that everything starts and ends with leadership. That is only true to an extent. I don't see how, this new chairman of EFCC, I don't know him very well, but he appears to be okay. He's not at least as gung-ho as some of the policemen who chaired that body in the past. But I don't think that his own philosophy, whatever it is percolating to the lower ranks in the organization. They still act lawlessly, corruptly, and so on. So there's a lot to be done. There's a need for an organization that tackles corruption and economic and financial crimes, especially in a country like Nigeria where corruption is endemic, especially in public life. But I'm afraid I don't think the EFCC is the answer.
What is the answer? What do you suggest?
I think there's a need for a new commission. It may be that you take what you regard as the best of the EFCC and the best of ICPC and the best of the police financial crimes unit, because there's no need to replicate those functions across 3 organs of the state and waste public resources. And it's better to have a single organization engage in fighting corruption, which is a real problem.
We have 3 organizations and the corruption is still endemic. If we have just one, wouldn't it be easier to...
No, I don't think it will be easier. I think what you actually need, I think the most important thing is culture and values. It's not a new legal framework. So when I say new commission, I'm talking more about the culture, the ethos and the values of such a commission. I'm not talking about the legal or legislative framework whereby you set up something called RATS PLC to catch rats. No, that's not what I mean. You've got to go beyond that, because it is clear that the problems we encounter in Nigeria are not due to the inadequacy of a legal framework. It's simply the unwillingness to enforce the existing framework. Whether it's political unwillingness or economic unwillingness or cultural unwillingness or religious unwillingness, there is absolutely no capacity to enforce the existing laws, and there is no willingness to do so. And so where you have unwillingness plus lack of capacity, it just means the laws are always going to be used negatively for collateral purposes, which is what we see with the EFCC.
I want to round off talking about local government autonomy. The issue of the control of the finance of local government, we saw that was recently put to rest with that Supreme Court decision.
Was it?
You don't agree?
I don't know. I'm listening to the question.
No, please share your views. You don't think that decision has put paid to that?
I mean, it has interpreted the law, but has that law been complied with?
Okay, in terms of implementation. Okay. The jury is still out on that.
The jury is out on that. You might say there are constitutional errors in the arrangements that we have, because in some respects, local governments do not have independent existence from the states. And I think it's just a caricature to say they do. But having said that, for good or bad, they've been created by the military people who gave us a constitution. And I dare say even under the 1979 constitution, they were also envisaged as a 3rd tier of government, which is a wholly erroneous view. They shouldn't be. They have local functions to perform, and in that capacity, they should have a measure of autonomy, but we shouldn't see them as people functioning wholly. So if you take a typical local government whose function is to administer the community, collect waste, pay primary school teachers, they do none of those things. And the reason they don't do them is because the governor seize and steal all the monies. And because there is no democracy, there's no local democracy, for the reasons I said, that the state electoral bodies simply announce the results given to them by the governors, you cannot say that those councillors and local government chairmen or chairwomen have been elected democratically. So it's a series of errors piled upon errors, or fraud piled upon frauds. They don't have any respect for rule of law, no respect for property rights, and the result is poverty, endemic poverty. And you can't change that. There's no way you can make progress if you have no respect for property rights or rule of law. If you want to do what you like, how you like, and when you like, that thing must have no value. It's like anything. Something which is so freely available, you can do it when you want, how you want, has no value. And that's why when you look at yourself, for example, as a journalist or as a lawyer, the fact that there are entry requirements, you have to undergo training, means that there are restrictions which ensure that there is some value to that profession. But if anyone can just badge in and say, I'm a journalist, the way that you see among social media practitioners online, you just see that it's a free-for-all. And something which is a free-for-all can never have proper value.
Away from that interview and in Rivers State, South Nigeria, the magistrates have asked the state government to consider increasing their retirement age from 60 to 65. They made this call during the second biennial conference of the Magistrates Association of Nigeria. The state governor, Siminaye Fubara, also used the opportunity of the event to appeal to the magistrates to continue to uphold the rule of law in the state.
As the largest component in the wheels of justice, curbing crime and ensuring a peaceful society rests squarely on your shoulders. Wherever and whenever your reach runs large, I plead with you, please ensure that justice is done and the rights of all men are respected and protected. I urge you that please, as you administer justice, ensure that rich and powerful are just, and then the poor and the weak are protected. That's the way society can be secure.
Let me therefore use this medium to appeal to the Rivers State government under the able leadership of an administrator par excellence, His Excellency Sir Siminaye Fubara, GSS-ROS, to set the ball in motion for the increment of the retirement age of magistrates from 60 years to 65 years by sending an executive bill to the State Assembly for the review of some of the laws directly impacting on the magistracy.
The theme of this year's conference, that is the role of magistrates in curbing crime and ensuring a peaceful society, is particularly pertinent in our current societal context, even as crime and peace are mutually exclusive, and society is in desperate search for peace amidst prevalent crimes and security concerns. This year's theme underscores the crucial role that magistrates play in upholding the rule of law and contributing to the overall security and tranquility of our communities. As custodians of the law, magistrates stand at the forefront of our legal system, embodying the principles of fairness, integrity, and partiality, as their cause are the closest to the people's cause. The role of magistrates, therefore, extends beyond mere adjudication. It encompasses the responsibility of fostering trust in the legal system, through their decisions, which have the potential to either prevent or provoke crime, uphold or undermine public trust, and foster or disrupt societal harmony. This places a great weight of responsibility on the shoulders of magistrates, calling for wisdom, fairness, and a strong moral compass in the execution of their duties.
Magistrates must ensure they know their laws. They must ensure they work in synergy with the community to also know about the values of the community. They must also ensure that they do training and retraining of themselves. Reading is part of the topic of law for your life. And they must have a good conscience and the fear of God, so that in dispensing justice, they would be fair and just. And then the society can be peaceful.
And just before we go, here's a quick recap of some of the top stories we're tracking at the court.
We begin with the report that the third annual National Judicial Council Conference on Judges' Performance and Evaluation has held in Abuja. The conference, which attracted judges from different states across the country and the FCT, stalled proceedings in some courts owing to the absence of the judges. The Chief Justice of Nigeria, Justice Kudirat Kekereekun, used the opportunity of the conference to express concerns over the increase in the number of pending cases in courts and the low rate of disposition of suits by some judges. According to her, Nigerians would lose confidence in the judiciary if judges continue to fail to deliver judgments in one quarter. She warned against laziness on the bench and urged judicial officers to refocus their attention towards enhancing their judicial performance. Despite the judges' conference, some courts still sat to hear matters pending before them. At the Federal High Court in Lagos, the Economic and Financial Crimes Commission (EFCC) on Thursday called its 15th witness in the money laundering trial of a former governor of Ekiti State, Ayodele Fayose. Fayose is being prosecuted by the EFCC over an alleged 6.9 billion naira fraud and money laundering charges. The witness, Mr. Joseph Machleb, was led in examination by the prosecutor, Senior Advocate of Nigeria, Mr. Rotimi Jacobs. In his testimony, the witness, who is not fluent in the English language, told the court that he works for a construction company as a mechanic. He also testified that he and his brother incorporated a company called JJ Technical Services Limited, which was run by one Aziz Mitchell. The witness denied that the company was involved in buying of properties, as the said Mitchell was not authorized to buy property for the company, a claim which was punctured by the Defense Counsel, Senior Advocate of Nigeria, Olalekan Ojo. Staying in Lagos, but this time at the State High Court, TBS, the driver of the bus rapid transport, BRT, Andrew Nice Omini Koron, standing trial for the murder of his passenger, Bamishe, on Thursday, opened his defense before Justice Sherifat Shonaike. The defendant, who was led in his testimony by his counsel, Abayami Omotubora, told the court that he didn't rape or kill Miss Ayowula, but said instead that 3 male passengers who boarded his bus after official hours raped and threw her off the vehicle. Andrew Nice, 47, was arraigned in March 2022 on 5 counts bordering on rape, conspiracy, felony, sexual assault, and murder of the 22-year-old on February 26, 2022 on the Lekki-Ajah Conservation Expressway. He is said to have conspired with others now at large to forcefully have sexual intercourse with a 22-year-old fashion designer, after which he allegedly murdered her. At the same High Court, proceedings were stalled on Tuesday before another judge in the trial of an undergraduate, Chidinma Ojukwu, charged with the murder of the Super TV Chief Executive Officer, Michael Osifo Ataga. Ojukwu, the 300-level mass communication student of the University of Lagos, is standing trial before Justice Yetunde Adesonya. She is being prosecuted alongside her sister, Chioma Egbuche, and one Adedapo Quadri for the murder of Ataga. The court had fixed the day to hear a no-case submission filed by Quadri and Egbuchu in the proceedings, but the absence of Egbuchu's lawyer stalled the hearing. Justice Adesonya has adjourned the case till December 5, 2024 for the hearing of the no-case submission. And we round off at the Lagos High Court in Ikeja, which ordered social media influencer Martins Otse, also known as Very Dark Man, to bring down the defamatory video and comments against Senior Advocate of Nigeria, Femi Falana, and his son, Folarin, popularly known as Fowls. Justice Matthias Daudu also restrained the self-acclaimed social media police from further releasing, publishing, or circulating any defamatory videos and comments against the senior lawyer and his son on all his online social media handles and pages pending the hearing of a suit filed by the duo. The judge also ordered that all the processes in the matter be served on Very Dark Man through his lawyer Deji Adeyoju. The orders are to lapse after 21 days. The Falanas had dragged the defendants before the court in separate suits, claiming 500 million naira each as damages over a video he posted on his social media platforms alleging that they collected 10 million naira from Idris Okune, also known as Bobrisky, to prevent the cause of justice.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Sheyede. Thank you for watching and see you next week.